Good morning, everyone. Welcome to our second panel. My name is Vicki Lemus. I'm an associate dean here at the law school, and I would like to extend my personal welcome to all of you here today. I'm very excited to introduce our speakers. I believe I'll start just on my with the presenters on my right and just go down the aisle for you. Sebastian Lantos received his BA in sociology from the University Center at Tulsa, summa cum laude. He graduated with a MS, Master's in Science, Occupational and Adult Education and Human Resource Development from Oklahoma State University in Stillwater. And that school, the School of Vocational Training and Continuing Education of OSU, was considered among the best 10 in the United States by U.S. News and World Report in 1998. He's the owner and manager of Sebastian Lantos, LLC. The company is incorporated in Oklahoma, has approximately 1,000 clients worldwide. It focuses in the language consulting area, including interpreting, translating, bilingual transcription, language acquisition programs, tutoring, language proficiency exams, bilingual and cultural training, interpreter and translator training, conference interpreting, voiceover dubbing, localization, voiceover for several corporate training and promotional videos, any language, anytime, any place in the world. His staff has worked in Cuba, Brazil, Mexico, Uruguay, Spain, France, Germany, Belgium, Argentina, and the United States. He's currently the president of the Governor's Council on Latin American and Hispanic Affairs in the state of Oklahoma.
Just member, not a president.
Oh, I'm sorry. To the present, I'm sorry. He's a member of that. And he is also former past president of the Coalition of Hispanic Organizations. He's a writer, columnist for Spanish newspapers in the Tulsa region, and he's from 1999 to 2004, he's the host of the Spanish radio program Su Opinion. Our next speaker is Professor Linda Allegro. She earned her PhD in political science at the New School for Social Research. She has taught at Hampshire College and Rollins College and is currently a visiting assistant professor of political science at the University of Tulsa. She has taught courses in Latin American politics, U.S. immigration policy, global migrations, and identity politics. Her forthcoming book with Andrew Wood is entitled Mexican Migrations to Middle America. Our next speaker is Kris Kobach. Professor Kobach received his Bachelor of Arts degree with highest distinction from Harvard University in 1988. He graduated at the top of his class in the Harvard Government Department. In 1988, the British government awarded him a Marshall Scholarship, which took him to England for postgraduate study. In 1992, he received his doctorate in political science from Oxford University. In 1995, he received his JD from Yale Law School. While at Yale, he taught undergraduates in the Yale Political Science Department, and in 1994, he won the Prize Teaching Fellowship, an award based on student nominations and faculty review. He also served as notes development editor on the Yale Law Journal. Professor Kobach was admitted to the Kansas bar in 1995 and served as a law clerk to Judge Danelle Reese Taha of the United States Court of Appeals for the 10th Circuit. He joined the UMKC School of Law faculty in 1996. He has published 2 books, The Referendum, Direct Democracy in Switzerland, and Political Capital, The Motives, Tactics, and Goals of Politicized Businesses in South Africa. He has also published numerous articles in political science, constitutional law, immigration law, and legal history. In 2001, he was awarded a White House fellowship, which took him to Washington to work for the Bush administration in the office of the U.S. Attorney General John Ashcroft. After his fellowship year ended, the Attorney General asked Kobach to stay on as his counsel. In that capacity, Professor Kobach served as the Attorney General's chief advisor on immigration law and border security. After the 9/11 attacks, Professor Kobach was put in charge of the Department of Justice efforts to tighten border security and return the rule of law to immigration. He led the team that designed and implemented the National Security Entry-Exit Registration System, which registers and fingerprints high-risk visitors to the United States. Within its first year of operation, the registration system resulted in the apprehension of numerous suspected terrorists. Professor Kobach also led the Department of Justice reforms of the immigration court system, resulting in the reshaping of the Board of Immigration Appeals in 2002. He left the Justice Department and returned to teaching law in July 2003. Professor Kobach has litigated a number of high-profile lawsuits in the field of immigration. He is lead attorney representing the city of Hazleton, Pennsylvania, in his defense of an ordinance that prohibits the employment of unauthorized aliens by businesses and prohibits the harboring of illegal aliens by landlords. He also represents U.S. citizen students challenging state policies that grant student tuition rates that grant residence tuition rates to illegal aliens in Kansas and California. He is senior counsel at the Immigration Reform Law Institute, a Washington, D.C.-based legal advocacy organization that represents U.S. citizens in immigration-related cases across the country. Professor Kobach has testified before Congress on 8 occasions. He is a regular guest on Lou Dobbs Tonight, The O'Reilly Factor, and MSNBC News, most often discussing U.S. immigration policy. He is also a frequent columnist for the New York Post and the Washington Times. He and his wife, Heather, have 2 daughters, Lily and Reagan. Professor Kobach teaches Constitutional Law 1, Constitutional Law 2, Immigration Law, American Legal History, and Legislation. Francisco Trevio is the executive director of the Greater Tulsa Hispanic Chamber of Commerce, a private nonprofit organization with the mission of growing business through people and partnerships. Before his current executive position, Mr. Trevio was in charge of the direction of Zapata Multimedia, which is the publisher of the Spanish newspaper Hispano de Tulsa, the oldest Hispanic weekly publication in northeastern Oklahoma since 1993. Later, Zapata Multimedia expanded actions and started publishing a community commercial guide called Páginas Hispanas. For the past 20 years, Mr. Trevio has advocated for the improvement of the general conditions of the Hispanic community while portraying the positive impact of the vast culture of the Latin traditions. His constant support to the arts has kept alive the Hispanic Festival, Day of the Dead, and the Children's Festival in Tulsa, Oklahoma. He has served on numerous boards, among them Girl Scouts of America, Coalition of Hispanic Organizations, Community Development Block Grant of Tulsa, and the Greater Hispanic Chamber of Commerce as one of the founding members. Currently, he is a board member of the Tulsa Performing Arts Center and the Community Health Coalition Connection. He is also a professional photographer and musician, an active member of the Catholic Diocese of Tulsa, assisting for over 2 decades to the St. Francis Xavier Parish. Mr. Trevio was born in Monterrey, Nuevo Leon, Mexico in February 1960 with his family in Tulsa, Oklahoma in November 1978. He is married to Margarita Vega Trevio, and he has 3 daughters, Ana Guadalupe, Sofia Guadalupe, and Camila Isabel. And with that, I will turn the podium over to our first speaker, Linda Allegro.
Thank you. Positioned here in Oklahoma offers possibly one of the best opportunities to assess the question driving this panel, which is whether to adopt more inclusionary or exclusionary policies on immigration. Oklahoma offers a timely case study given that the Oklahoma legislature voted for a resounding position of exclusion. The Oklahoma Taxpayer and Citizen Protection Act, also known as House Bill 1804, went into effect November 1st of 2007. It established the most far-reaching measure to date to control for illegal immigration. While various counties and cities, localities throughout the nation have passed restrictive measures for controlling immigration, 1804 established the unprecedented enforcement of federal laws at the state level to be administered by local authorities. Among these new measures have been the denial of social, educational, and health-related services to unauthorized migrants, the criminalization of those who knowingly harbor and transport illegals, increased authority by local law enforcement to carry out federal immigration procedures, and the penalization of employers who fail to comply with new employee legal status verification. And if you were here for Elizabeth McCormick's talk, she gave an eloquent presentation of those new statutes. In this week, the Oklahoma legislature was deliberating over House Bill, what was potentially House Bill 3348, known as the son of House Bill 1804, to kind of further extend provisions to, among other things, make English the official language of the state, confiscate property of illegals, as well as deny U.S. citizenship to children born of undocumented mothers. Given the restrictions established under 1804 and these possible extensions under 3348, Oklahoma serves as possibly the exemplary case of a policy of immigrant exclusion. Often the refrain by those who support these restrictive measures is that we are not against immigrants, we just want them to be legal, suggesting that the contention is with the illegals and hence the need to extricate illegals from society. Moreover, this preoccupation with legality often shields restrictionist groups from accusations of racism, often leveled at them. In other words, this preoccupation with illegality offers a degree of racist deniability and in some respects becomes a new code word for race. We are not against brown-skinned people, we just want them to be legal. All the while, of course, there is virtually no legal avenue they can access. Furthermore, this preoccupation with illegality is a very selective one. The heavy-handed punitive measures are directed at poor migrants and their families. There is very little scrutiny of the many acts of illegality that are structurally embedded in such labor arrangements. For example, there's a tendency to ahistoricize the experience of migrants. Instead, the condition of illegality becomes naturalized. That is, it just exists in nature. There's legals and illegals, with no attention to the structural factors, indeed the laws which have positioned them as such. We all know that, for example, the rise of undocumented population in the 70s and the 80s is a direct result of the passage of IRCA. Which led to the passage of IRCA, which resulted from the removal of legal arrangements established under Bracero, which facilitated the movement of transnational workers. More importantly, we are not talking about confiscating the buildings, the highways, or food produced in the informal economy or with undocumented labor. Indeed, the clothes we are wearing and the food we just ate and the building that we are in may very well have been constructed in part with illegal labor. Instead, the laws seek to confiscate the hard-won property of working migrants. If we are truly about the rule of law, why are the punitive measures so clearly lopsided? Historically, we have only tokenly penalized employers who have partaken in illegal arrangements. So the preoccupation with illegality is a select one with selectively enforced institutionalized punitive motions to criminalize migrant workers and to discipline that labor force. I'll get back to employers in a moment. Well, in the months leading up to and following the passage of 1804, thousands of immigrant families, mostly Mexican, departed the state. There has been a statistically significant out-migration of Hispanics, or approximately 14% of the total Hispanic population of the state. There are projections that more will leave after the tax season, in which they will, collect their taxes and file and pay their taxes, collect their taxes if they're eligible, with few new recruits to the state. The 2005 U.S. Census accounted for approximately 175,000 Hispanics in Oklahoma, or about 6% of the total population. In response to 1804, we have seen an exodus of somewhere around 25,000 Hispanics to neighboring states and some return migration to nations of origin, especially Mexico. So on some level, the bill did what it intended to do, which was to extricate Mexican undocumented workers. In a celebratory tone, the author of the bill, Randy Terrell, and his like-minded groups and individuals proclaimed that the bill has led to self-deportations, hence accentuating a policy of exclusion. But what was not projected was the significant exodus of documented legal migrants and other Hispanics. This is largely a result of the fact that many Hispanic and other immigrant households are often mixed legal status homes with a range of legal statuses within one household. The migrant flight is attributed to the enormous fear and intimidation thrust on the community under deportations or the threat of deportations, what in the academic literature we refer to deportability, that is, living under the radar of possibility of being apprehended, deported, and thus being separated from a family member. Under this fear and uncertainty, many families opted to leave together. What arises under a climate of fear are degrees of abuse resulting from the very power relations that ensue. Such exclusionary practices, in fact, create unlawfulness in terms of the infringement on civil liberties of migrants and citizens. With institutionalized fear comes abuse, the stripping of civil liberties, and the further docility of the targeted community, hardly the laudable attributes of the liberal democratic tradition of the United States of America. As a result of the exodus of migrant workers, including documented workers, we have seen now the mobilizing efforts of business and commercial sectors which oppose portions of the bill that hold them accountable for the new legal configurations. Chambers of Commerce and other business associations have filed a lawsuit to reverse the order. This is not really anything new. In many respects, this is reminiscent of the employer sanctions debates and provisions introduced under IRCA in 1986, which imposed sanctions on employers who ostensibly hired illegals. That was a very messy situation, and in the end, employer sanctions became nothing more than the token and highly symbolic act to address the demand side of the immigration equation. That is because it is virtually impossible to accurately and fully monitor every employer, as well as due to the enormous opposition in the business community to have to become immigration agents. What IRCA led to is the proliferation of an industry of fraudulent documents to circumvent these new employer requirements, of which all parties were aware, and the strengthening of subcontracting arrangements to shield some big business from having to be subjected to all this scrutiny of documentation of employees. What is interesting about what this debate has spawned is that the public doesn't seem to have much sympathy for employers who are perceived as not following the rules and adopting unscrupulous employment practices. But what the economy is up against is the possibility that those employers will also leave the state in search of more business-friendly environments, as their employees have, or increase their prices, which will be, in the end, more costly for consumers and hence the citizens and taxpayers of Oklahoma. In conclusion, such exclusionary practices bent on extricating illegals has not necessarily translated into any meaningful or significant material reward or gain for American workers. Extricating illegals from the economy has not translated into better wages, more secure work opportunities, or other significant work possibilities for low-wage American workers. If anything, we are actually hearing stories of American workers in restaurants, for example, who complain that the bill has left them understaffed with more work thrust onto them at no extra pay. In some of the ethnographic work I have conducted, some respondents say, "We didn't really know there was a problem until Randy Terrell made it one." If we really wanted to restrict immigration, we might begin by focusing on sustainable economic development in sender nations as a way to assuage migrant flows. We could reroute the enormous amount of money spent on border fencing, for example, and focus on meaningful and sustainable transnational development. We could also focus on raising the wages of our American workers as incentives to incorporate them into the dirty jobs they won't take. But what we definitely shouldn't do is continue to scapegoat. But what we definitely shouldn't do is continue to scapegoat Latino workers through extreme exclusionary measures, holding them accountable for the many illegalities embedded in our political and economic milieus. Thank you.
Thank you, Professor Allegro. Our next speaker is Professor Kobach.
Good morning. Well, we'll definitely have some divergent points of view on today's panel, so hopefully you'll enjoy that. As was mentioned in the introductions, I'm senior counsel at the Immigration Reform Law Institute in Washington, which is an organization that does litigate some of these cases, particularly under preemption law, and does advise some states on what they can and cannot do to reinforce the efforts of the federal government to enforce their immigration laws. And the Immigration Reform Law Institute did provide advice to Randy Terrell in the drafting of 1804. And I'm quite confident that if the issue ever reaches the merits, as you may well know, the first case was already dismissed on standing grounds. If the case ever does go to the merits, I'm quite confident that the law will stand up under preemption review, which is the primary argument that would be levied against it. As lawyers, I assume we're all lawyers here, or just about all of us are lawyers. I assume we also take the rule of law seriously. And if we take the rule of law seriously, then we must believe somewhere in our hearts or minds that laws should be enforced. And so if laws should be enforced, then that brings me to my position, which is that in immigration law, laws are by definition exclusive. I mean, of course, there are some laws that facilitate adjustment of status, but by and large, the bedrock of immigration law in every country on the face of this planet is to exclude and control the people who are not citizens and the conditions under which they may enter. I mean, that's what immigration law is by definition. And while we can say that we should adopt a position of inclusivity and we should adopt a position that is different from what we have right now, the reality is that every country on the earth wants to have some control over its the inflow of new people. And you know, Milton Friedman is the one who probably explained the economic rationale best, and he said that it's impossible to have a welfare state, to combine a large welfare state with unrestricted immigration. You have to have, as long as your government is giving out goodies, and just about every government on the face of the earth does that, then you want to control who has access and who's coming in, and therefore you can protect your own citizenry from job competition, if that's what you protect from, or if you want to protect from the allocation of benefits in order to give your own citizens priority in the allocation of benefits, you name it. With that said, I want to talk a little bit about how a regime of exclusivity, that is to say the regime that every country on the planet has, can be made more effective. Because there's one point on which I'm sure we all agree is that our immigration laws have not been enforced particularly well. And indeed, when our immigration laws are enforced so poorly, that is when claims of inhumaneness are the strongest. Because if it is so rare that someone is actually removed from the United States, then it seems particularly cruel. When everybody else is here working and they're skating by and evading the law, why does it hit this one family or this one individual so hard? And so I think a rule or a system or a regime in which we have a consistent enforcement of the law is a better one. It's certainly a fairer one because there is no randomness or arbitrariness associated with the enforcement of the law against any particular individual. So how do we go about improving the situation from where we are now with so much lawlessness and go to a situation where people can actually expect that the law will be enforced somewhat consistently, or more consistently than it is right now, let's put it that way. I think right now we're gripped by a false dichotomy in this country, and we're constantly told at the national level that there are really only two options. We have 12 to 20 million people unlawfully present in the United States, and the only options available to us are either so-called mass roundups, where the government actually goes out and physically tries to find each person unlawfully present and then put them into removal proceedings and then detain them perhaps during those proceedings, although that we don't have enough detention beds to do all of that, but you know, that we should actually physically remove all of those people. Or option number two is grant a mass amnesty, which in effect rewards illegal behavior and says, hey, it's okay. We weren't serious about our laws in the first place. Well, there's no other area of law where we present that kind of dichotomy. We don't say with regard to the problem of drunk driving that the only options are positioning a police officer at the door of every restaurant and every bar in Tulsa and do a breathalyzer exam on each person coming out of the bar before we allow them to go to their vehicle, or just get rid of our drunk driving laws and say that anything goes. We don't say that. With respect to theft, we don't say that the only options are a police state where you have an officer posted on every block of the city, or a situation where we abolish our laws against theft. We don't say that either. No, in fact, in most areas of the law, we have a regime of ratcheting up enforcement to deter violations. And to use the example of highway speeding, I think that's probably the most appropriate here to find. It's hard to find a perfect analogy. But if you have a section of road where everybody's speeding, and they've been speeding for decades, and everybody knows that there's never going to be a police officer out there in a speed trap, people change their behavior. And they say, okay, it's okay for me to speed here. I know that I can get away with it. And more people will take that route, as a matter of fact, because they know that they can speed on that particular highway. Now, the options are not limited to arrest every speeder, issue a ticket, detain each person that speeds, versus get rid of the highway laws. The best option is you just put an officer out there in a patrol car and you hand a ticket to 1 out of every 50 speeders. And suddenly everybody changes their behavior because there's a realistic probability of enforcement. The same goes for immigration law. If we want to take our laws seriously, we need to make immigration enforcement something where there's actually a realistic probability of law breaking being caught. Now, this obvious concept has never been tried at the national level in our history of immigration laws. To be sure, the IRCA, Immigration Reform and Control Act, of 1986 made employing an unauthorized alien a crime for the first time in U.S. history. And to be sure, the Illegal Immigration Reform and Immigrant Responsibility Act, say that fast 10 times, of 1996, IRIRA, as it's sometimes abbreviated, also increased penalties and increased the enforcement orientation of our immigration laws. But still, the executive branch has been woefully unable to enforce in anything like a comprehensive way. Part of the reason is that we only have about 2,000, well, it's now higher than 2,000, but only a few thousand interior enforcement agents in ICE to cover the whole country. Most large police departments in any given city have more than a few thousand officers. And so the credible threat of enforcement hasn't really been there. Instead, we've had a strategy of triage. And basically this strategy is this, and I'm sure many of you are familiar with it to the extent that you practice in this area, and that is that if someone is a smuggler, ICE will definitely try to incarcerate that individual, and they will be put into the criminal track for prosecution. If a person is an illegal alien with a criminal history, ICE will do everything they can to deport that category of individual. But if a person is a, say, garden variety alien unlawfully present in the United States, chances are, although there are exceptions, but chances are that person is not going to face a serious threat of enforcement. Indeed, ICE may tell the local official who runs into that individual, no, we're not even interested in picking them up. And this strategy of triage means that the vast majority of people unlawfully present face no serious threat of enforcement. So, what does this have to do with state and local law enforcement? Well, the reason that this ties in very well, this in the strategy of actually trying to ratchet up enforcement and use that as the way to bring about some change in our immigration law situation is called attrition through enforcement. And I think we've seen it now demonstrated at the state and local level that attrition through enforcement works. In other words, the strategy is not to round people up. The strategy is to encourage people to self-deport. And we have empirical evidence that it works. I think Arizona is actually the best case study, although House Bill 1804 in Oklahoma was an omnibus bill that took a number of measures that the state is perfectly permitted to do to increase the enforcement of immigration law. It doesn't go nearly as far as Arizona has done in a series of laws. And the most dramatic was, of course, Arizona's law passed in the 2000 session to require every employer in the state to use the E-Verify system. And that took effect on January 1st, 2008. I was involved in assisting in the drafting of that law, and we prevailed in district court in Arizona on February 7th, 2008. That case is, of course, going to the Ninth Circuit, but the judge has declined to stay enforcement of the law since then. So the law's been in effect for about 2 months and a week, and we're already seeing extraordinary effects. Now, what is the E-Verify system? For those of you who don't know, it's the system that was developed pursuant to the 1996 Act, which gets around the fraudulent documents problem that our previous speaker mentioned, and that is, of course, since the 1986 Act, all an employer has to do is show that he has not knowingly hired an unauthorized alien, and part of that involves the inspection of documents through the I-9 process. And, of course, there is a huge cottage industry in the manufacture of counterfeit documents, and that industry has done very well to defeat the intent of the 1986 law. Well, in 1996, Congress ordered, and over the next 12 years, the executive branch created the E-Verify system, which in 2004 was transformed from a pilot program and made nationwide. Now there are about 55,000 businesses who participate in the program, and the number is increasing at about 1,000 businesses per week. On January 1st, there were 20,000 businesses in the program, but when Arizona's law kicked in, all of Arizona's 145,000 employers were required to join the system, so that's why it's been going up at an even more rapid level. It was going up at about 100 a week last year, now it's about 1,000 a week. What does the system do? Basically, you register for the program as an employer. When the person's filling out their I-9 papers, you log on, you type in the employer's name, date of birth, and a number. If the person asserts U.S. citizenship, of course, you'd type in a Social Security number. If the person asserts that he's an alien authorized to work in the United States, you'd type in his employment authorization number, and then you get an answer back from the federal government. In 92% of the cases, the answer is yes, the person is work authorized. Go ahead, continue to hire him, or technically, in this legal fiction, the person has already been hired. In the other cases, you get a tentative non-confirmation, which means that if the individual believes that he is work authorized, he may then have an 8-day period to contest Some of these tentative non-confirmations, in fact, the vast majority of tentative non-confirmations are resolved, where the individual actually is work authorized, are resolved very quickly. Typically, they are either maiden name situations where an individual U.S. citizen, for example, has not, the day after her wedding, she didn't go to the Social Security Administration office and say, hey, by the way, my last name's changed, and so the federal government has the wrong last name. Some of them are also time lags with regard to naturalization. Someone has gone from green card status to U.S. citizen, and the central database housed at the ICE, or the Department of Homeland Security main computer in Kentucky hasn't yet been updated to reflect the fact that the person's now a U.S. citizen. But at any rate, the system works very well. And businesses who are polled after they use the program say they love it. The numbers are, I think it was 94%, if I'm remembering correctly. Businesses say they vastly prefer it, or greatly prefer it to the previous system of trying to scrutinize documents and relying entirely on their own judgment, whereas this allows them to rely on the federal government's judgment. Okay, so what's the effect of the Arizona law? Well, it's had a profound effect in encouraging people to self-deport. Now, if self-deportation is, if encouraging people to start following the law themselves is a bad idea, well, then we're going to, this debate's going to be like two ships passing in the night. But I assume that if we do think that encouraging people to follow the law themselves is a good idea, then that's probably a good thing. And the numbers self-deporting are, in the tens of thousands. And we know that they're not just going to neighboring states. The people unauthorized to be in the United States are also returning. Those of whom are of Mexican nationality are returning south across the border into their home country. We know this because the neighboring state of Sonora, Mexico, sent a delegation of 9 legislators to talk to the Arizona legislature in mid-January. And their complaint was that you're putting this law into effect too quickly. You're overburdening our schools and our public benefits and our housing stock in Sonora because our returning nationals are coming too fast, and we can't handle this burden. So clearly, and some people would say that is evidence of a great degree of chutzpah, considering that the Arizona schools were complaining about the same things only a few years before. But at any rate, it is working to initiate self-deportation. The Oklahoma statute is some of the statistics were just presented, suggesting that there is a departure of unauthorized aliens. I tend to distrust I agree that there certainly is. I don't know that we can, look how carefully we can look at the numbers that are based purely on race, because again, for me anyway, this is not an issue of race. This is an issue of legality. And although the people of Hispanic ethnicity comprise a disproportionate share of the illegal population, unauthorized alien population in the United States, there are obviously other ethnicities involved as well. Okay, one other example we have of the effectiveness of attrition through enforcement is the NSEERS system, which was mentioned in the introduction. I was involved in developing for the Department of Justice. The NSEERS is the National Security Entry-Exit Registration System, put into place shortly after 9/11. Actually didn't get fully rolled out until about a year after 9/11. And that system, basically it's called a system of special registration, and people who fall into certain categories, most notably coming from state sponsors of terrorism, are scrutinized more carefully at the border and are asked to check out on the way out. As you may know, 5 of the 19 hijackers after 9/11 were unlawfully present in the United States, most by overstaying their authorized period of stay on a B visa, a couple others for other reasons. And we didn't know it. In other words, we, the federal government, didn't have a warning flag that went off and said, or a warning signal that said, oh, hey, by the way, this person has overstayed. Why has that not happened? Because we don't have a system of departure controls in this country. Most countries do have departure controls, but we just check people in. We don't check people out. If you're not checking people out, you don't know when someone's overstayed or not. You don't know who's left. And we realized that to dramatic effect on 9/11. And so what the NSEERS system did was said, well, for this category of high-risk aliens, we will actually check people out. We will require them to actually depart. And you've probably seen these U.S. visit kiosks at the airports. Those are part of the checkout process. And then there are penalties in place for people who don't check out. If you fail to check out, you're forever denied. You're barred, basically, from re-entering the United States lawfully. In addition, the NSEERS system required people from certain countries where al-Qaeda had a presence to come in and register, people lawfully present to come in and register their presence, and they would be obliged to check out when they left. Now, one of the biggest countries, indeed the biggest country that was involved in the so-called call-in process was Pakistan. And a lot of people were in the process of Pakistanis coming in and registering with the federal government. It was found that a lot of people were unlawfully present, and about 1,500, rounding the numbers off, Pakistani nationals were placed into removal proceedings. But in addition to that, about 15,000 Pakistanis, it is estimated, self-deported. They actually left the country. How do we know? Because actually many of them went to Canada, and many of them went back to Pakistan. But both of those countries reported a huge number of returning nationals. So we have two examples of how self-deportation works. If you ratchet up enforcement a reasonable amount, you can actually encourage people to leave on their own. Now, I would say that this is a good thing. It's good for two reasons. One, there is a certain amount of humaneness that goes with people deciding on their own, voluntarily, to start following the law. It's far better if people say, you know what, it's getting harder to break the law in the United States or harder to break the law in Oklahoma, I think I'm going to leave. And then they make their own arrangements. If they have family members with them, they do it in a way that is not disruptive. No one's detained, and they make those choices individually. And I think we can all agree it's a fundamental principle of philosophy or anything else that when individual choices are driving things, then you're going to have greater freedom and greater happiness, greater utility if you're a utilitarian. It's also cheaper, much cheaper, to have people self-deport than to place them in removal proceedings. Removal proceedings are expensive. If there's any detention involved, you're talking about $75 a night to detain someone. You're talking about the salaries and the costs of the immigration courts, then the Board of Immigration Appeals, and the cost of an appeal to the U.S. Circuit Courts. It's very expensive for removals to actually occur. And so to the extent that we can encourage people to leave on their own, that is a good thing. And finally, I'll wrap it up by saying that Oklahoma, Arizona, and the NSEER system, give us a roadmap for what our policy should be nationally. I think the best thing we could do to encourage the broad enforcement of the law nationally is to mandate E-Verify across the country. That was part of House Bill 4437 that was passed by the U.S. House of Representatives in November or December of 2005. Never got a Senate vote. That was the year we had dueling bills, one out of the Senate, one out of the House, and neither chamber voted on the other chamber's bills. Hopefully, that will be the reality in the next few years, and that if that happens, we will see dramatic transformation. One last point that I would like to make, and that is that what Oklahoma's law does is certainly sweeping compared to the status quo prior to the bill, but these things are some of them are not only fairly small or incremental steps, they're things that were already required by federal law. In 1996, with the Welfare Reform Act of that year, which was passed within a couple of months of the Immigration Reform Act of that year, it became illegal for any state to offer public benefits to illegal aliens, which is the broader category than unauthorized aliens. And so Oklahoma, by denying public benefits and making the same exceptions as are required by federal law, and that's found in Title 8 U.S.C. Section 1621, by making the same benefits, Oklahoma brought itself into compliance with federal law. It's not as if Oklahoma went out on a limb by denying public benefits. And of course, there are exceptions. Exceptions are K through 12 education pursuant to Plyler v. Doe. Exceptions are emergency medical care, immunizations, disaster relief. Those exceptions are all built into the law, and that's perfectly reasonable. Indeed, it's not only reasonable; it's required for Oklahoma to comply with federal statutes. So I will wrap it up there and enjoy the remaining presentations.
Thank you, Professor Kobach. Mr. Trevio.
Hello there. How are you? Well, I'm not a lawyer, but I do play one on TV. So, well, Oklahoma does have a problem. Personally, I think that problem is called Randy-Taro. So we're going to go on. What did I do now? Here we go. Here we go. The problem statement, Oklahoma has seen a twofold problem in human capital policy. We have both a workforce shortage and a work skills shortage, with both representing long-term trends unless action is taken. Without improvement on both dimensions, Oklahoma will not meet the needs of our key states' industries. That includes construction, lodging, restaurant, lawn maintenance, etc. So let's talk about some of the facts. The real facts, according to the U.S. Census Bureau, the only demographic that had a significant growth since 2000 was the Hispanic population. There's a growing ethnic and cultural diversity, rapid Hispanic growth, particularly among the population less than 25-year-olds. 25-year-old is informing us that young immigrants' families are coming to Oklahoma to settle, to work, and raise their families. And Oklahoma, Tulsa, I think is a great place to raise a family. Other real facts are the Department of Commerce has stated that in 2005, that Oklahoma gained 297 Hispanic-owned businesses from 1997 to 2002, representing almost a 46% increase, the largest among minority-owned businesses in the state of that same period. Other real facts are the Department of Commerce stated in 2006 that Hispanic-owned businesses with paid employees also had the greatest measured percentage increase, more than 311 million, or around 46% of sales and receipts for the period between 1997 and 2002. Also, another note that the Hispanic buying power in the state of Oklahoma is around $1 billion a year. Present in Oklahoma, many Hispanic businesses are closing their doors to go to neighboring states and also their land of origin. I happen to know a few. Some of them went back to California, also went back to Mexico, selling most of their items they had in the stores basically at cost. Citizens and residents are leaving our states. Many of my friends have left. So, it affected me personally. Most of my friends are undocumented. And the undocumented immigrants are leaving for fear that is being created by ignorant laws. The rest are leaving because they do not feel welcome in the state of Oklahoma. So why is Oklahoma saying that Oklahoma is a business-friendly state? If that doesn't change Oklahoma, the future of Oklahoma, there will be too few Oklahomans with the skills to fill our industry needs, fewer companies that can expand or choose to locate in Oklahoma, and a state that would not be in disadvantage to compete against other states. The other thing that I don't know if you know, but do you know that Mexico is the largest exporter of Oklahoma products? True. In conclusion, Oklahoma can solve both work shortage and skills shortage that our industries face by committing ourselves to a strategic and fair, just, comprehensive, and sensible immigration reform. Without that plan, many Oklahomans will continue to be excluded from being part of a positive, productive workforce. So, is it okay for Oklahoma to have a law that promotes hate among people? I don't think so. House Bill 1804, to me, is not the solution. It's not about immigration anymore. It's about hate. And who's promoting that hate? Together here, Minutemen, White National Alliance, and wannabe state senators. That's part of the problem. Also, talk radio promotes hate, like Chris Medlock, 1170. Jim Christ on the hate rallies of the Minutemen. And also, of course, the future of adults promoting hate and teaching their kids to hate. On the amnesty, a lot of people say that immigration reform was amnesty. It is not amnesty when you have to pay $5,000 per individual. It's not amnesty when they have to go through a criminal background check. It's not amnesty when you have to leave after 3 years and reapply. A family of 5, that would be $25,000. Who has $25,000 right now? So, it's a hate issue, and it's a sad issue for the state of Oklahoma. Who are the affected ones? U.S. citizens, mostly children. For example, Miguelito here, a U.S. citizen. Mom and dad are undocumented, live in Tulsa. Entire families, broken. 2 of these 2 girls, they're all sisters. 2 are U.S. citizens, 2 are undocumented. Mom and dad are undocumented. They volunteer. They're actually altar girls, St. Francis. Mom and dad very, very active in church. And the solution, integration, a reformed but fair, just, comprehensive, and sensible. We need these people. We need workers. Integration. A sensible immigration reform. And thank you.
Thank you, Mr. Trevino. Mr. Lantos.
Good morning. Thank you to you for having this debate in such an important historical time for Oklahoma. Janet Levitt, thank you for organizing this. My presentation actually has to do a lot with 1804, but if I have some time without being a lawyer and risking my integrity, I'd like to answer to some of the statements that Mr. Kobach did. So I'm going to go as fast as I can with this. We're not talking anymore about the M.L. Lazarus poem at the foot of the Statue of Liberty or Pluribus Unum in our currency, and we're not talking in the Bible about helping our neighbors anymore. We are talking about myths and the economic part of immigration. I think this was created by terrorist threats and attacks and a slowing economy. Before this, President Bush was all for some type of reform. It was not an issue. But obviously, after these things that happened to our country, things started to change. I equate this to what's called a retrovirus in medicine, where it's dormant, and a virus is dormant, and all of a sudden the conditions are met to flourish, something that is bad for the body. In this case, it's bad for our community. The type of immigration law that we have right now. And Oklahoma has become ground zero of this lab to see if it works. Arizona as well. Unfortunately, there's only 3 states out of 50, so there's other 47 states that are maybe trying to see what will happen here. So we are in the middle of this experiment. This starts with misinformation and myths by anti-immigration groups. And I heard some today, for example, equating the criminal law to the civil law. And again, I'm not a lawyer, but my understanding is if I compare somebody that broke the law and there's a police involved, and the immigration law being unlawfully present in the United States, one is a civil law and the other one is a criminal law. And I might be mistaken. That would be like if I am guilty in a divorce, I would go to jail. I still can't understand why they're named criminals if it's a civil law, and especially when they are paying taxes, and especially when they want to become legal and they don't want to remain in their status. So that's, I think, one myth, to label them as criminals. The tax issue is another myth that was created by this nativism and this xenophobia, and they do pay taxes. Again, if we have time, I'd like to demonstrate that they're taking jobs. The demographics don't show that. As a matter of fact, our aging population has a problem of a tax base if we don't expand our immigration because of our birth rate. So all these things equate to the misinformation and myths of these anti-immigration groups. Now, let me preface by saying that we want safe borders, we want people to check out, and we agree with the rule of law. And let me clarify that here in a little bit. But we have to change the laws the way they are in immigration. The word illegal, before I continue, historically can be interpreted in different ways. The Chinese Exclusion Act, it would be like saying we want to enforce the law because of the Chinese Exclusion Act. With the Irish, we have excluded them at the beginning of the century. With the Native Americans, and the most incredible enforcement of law would be before 1964, when a black lady was sitting at the front of a bus. And all of a sudden in 1964 the law changed and it was legal. So what law are we enforcing if it doesn't work? That is the point that we're trying to make. We need a comprehensive reform with a safe border, and notice that we need some workers in the United States, and do that before our communities are torn apart, like it's happening right here in Tulsa, Oklahoma. So the there's a resolution in Oklahoma that is basically done to support 1804. Before 1804, the Senate says, well, we need some document to prove that undocumented are taking our money, that the taxes, everything that we just talked about, that they're overloading our system, that the criminals, the schools, all this is overflooded. And this is the wording with words like Oklahoma's had a tradition of welcoming all persons, they have to pay their share, creates a considerable burden on the resources of the state, the undocumented, hard-earned tax dollars redirected to benefit those who enter the country and stay illegally, adequate, utilize, and protect the valuable resources and services. This is the resolution that creates a task force in Oklahoma to try to justify 1804. This was done before 1804. So to me, it was interesting to read the conclusions of this resolution, the report. Because theoretically, with all the power of the state and all these people that went to this task force, we could have a clear picture. And I'll be the first one to change my mind if I see that undocumented people, first of all, if they break the criminal law, as a court interpreter, certified court interpreter, I'm the first one to assist in law enforcement. Maybe if they break the law and it's proved in the court of law, nobody has any problem in deporting someone like that. But to say that they are criminals when they don't break the law, the criminal law especially, is something far more different. So this report is interesting to me because it tries to give a basis to 1804. These are some basics of this task force. And all of a sudden, these are some of the highlights. We're in a surprise here. 1804 is ready to go. We have terror. We'll have everybody trying to say, yes, they're taking our jobs, our taxes, everything, all those myths that we talked about. All this retrovirus that just comes up in our community just unfolds itself with this 1804. However, the highlights and the quotes of this report start saying, well, employment, there's less than 80,000 permanent visas, that we need 1 million immigrants workers each year. We have only 5,000 permanent immigrant visas for low-skilled immigrants. 5,000 visas in the United States. I mean, Greenleaf Nursery needs 600 people a year to do their little plants and flowers. And we have 5,000. So there is a problem with the law right now. That's why should we enforce this law? And that's where I beg to differ with Professor Kobach. Why should we enforce this if we know that we need these people? So, these are other highlights. We have the Department of Human Services. Look at these numbers. 0.06 people undocumented. That's of the budget. That's how much they consume. 0.06. That's how much this is on the report, by the way. The estimated Medicaid cost for illegal immigrants is 0.6 of the total Oklahoma. And we're talking maybe a population that's 5%, 6%, 3%, 2%. This is 0.6. Patty Davis. Now remember that the Senate did this to try to justify 1804, and they cannot get any sentence here that supports that. Patty Davis. It says $515 million in uncompensated care in 2005 to persons who were uninsured or underinsured. Well, we don't know if they're undocumented or not documented. That's a health national problem that I wish we could resolve. Paul Hitch Enterprises, Guyman, Oklahoma. I think it's Texas County, if I'm not mistaken. They depend on these people, and the county depends on these people, just like LeFleur County. There's a lot of counties that depend on this. They don't have workers. A business has very little incentive to ensure the legal status of its workers. These are people that were invited by the senators to justify 1804. Walter Morris, prohibiting undocumented workers will hurt Oklahoma's ability to compete in the global market. Tim Curry, AFL-CIO, exploitation. Protection for employers experiencing such exploitation would have to be established legislatively. The director of the tax policy, with the TIN numbers, they pay taxes. The Commission estimates that sales generated by those with payer IDs, along with their dependents, around 9.1. This does not even include the sales tax, property tax. It's another myth that is wrong. They pay every single tax with false documents, but they never will recover that FICA. The sheriff, these are quotes straight from this report. 330 detainees. There's probably 60,000 undocumented. Leanne Taylor, she explained the federal mandates that they can't ask, basically, in school. Richard Gilbertson, Director of Workforce Integrated Programs here in Oklahoma. If legislations were enacted to open a legal path for currently undocumented workers, it would help assuage the labor shortage. The conclusions are definitely my favorite part on page 13. After reading all this and after having all these people talk about this, the conclusions are really, if I was a senator, I would say, you know what, we have a problem here. Here's where they have to decide, are we going to include these people or are we going to exclude them? Are we going to try to bring them in our society, teach them English, teach them how to drive, become, good residents and citizens, like in Israel, the Ulpan plan, for example. There's a lot of cases in the world that do that. No, the Senate and the Oklahoma legislature decides to exclude them, even with these conclusions. It's that retrovirus again, and the fear that Mr. Trevio talked about. Here are the conclusions. There's a need to establish a method allowing the state attorney general to request federal compensation. Of course, they get paid sooner or later. Okay, there's 350 people, detainees that are undocumented. Let's get whatever number for the federal government. Who doesn't agree with that? That's fine. Conclusion about education. The desirability of educating undocumented persons in the state and the low impact of current undocumented persons. So they recognize that there's a building. It's like a jail. There's already a building. There's already teachers or wardens. If we put 5 kids more, it's not going to hurt the operational part until a certain point. We have already the buildings and the teachers. Now, if you get 1,000 more kids, 10,000 more kids in a population that has 5 kids that are U.S. citizens, it might happen. But you know what? They pay property taxes. So all that is calculated in that equation. Next conclusion. Many of the critical aspects of immigration policy are established. Now, this is the conclusion of the state Senate in Oklahoma. I just can't understand. Preempt. That's why 50 states are not enacting these statutes, because the federal government eventually will have to come to terms with this. Even Secretary Chertoff agrees with this comprehensive change. The Homeland Security Secretary agrees with this. He has been tapped by Midwestern farmers and ranchers saying, if we do this, we won't have food in the tables of the United States. That's why it's a national security issue. And I heard that on NPR. The state of Oklahoma faces a labor shortage again with unemployment less, of course. There's an aging population, and if we forbid everybody else to come in, see, our problem right now is not immigration. We have to include them in a comprehensive way, with safe borders, educate them. Our problems are the environment, our competition with China, wars. Are we going to forget about all that and just dedicate to the very poor and indefensive people? Yes, that's what we're doing in Oklahoma. So, the legislation regarding labor will therefore need to now this is, instead of saying all this, they say, you know what, even though we have a lot of people saying that we need workers and that we have labor shortage and there's abuse, this is one of the conclusions. We have to deter employers from hiring illegals or undocumented workers. Now this is before 1804, okay? This is after 1804. Ask the Chamber of Commerce, the Hispanic Chamber of Commerce, how many calls they get asking for employees. There's just no people right now to work in Oklahoma for certain jobs. We have to change this law to make it comprehensive, to have an amount of people that have to come in, maybe on a temporary basis, but we just can't sustain this loss. 30,000 people based on the Metro Chamber left. We have CNN. We have MSNBC. We have all these national media coming to Oklahoma, but not for the arena, which should be our pride and joy and everybody that, no, they're coming here just to show in Plaza Santa Cecilia how many pickups leave every weekend. And they film that. Several lawsuits are filed. Who wants these lawsuits? Unless you're really an attorney, who wants these lawsuits for the community of Oklahoma? It's divisive. No, and I say that seriously. I didn't mean it on a funny way. It's a feather in your hat if you win this lawsuit. If you lose, it's not. But for the community at large, there's nothing worse to have our neighbors going back and forward. I have 5 minutes, and fortunately, I can talk about this. It's called Taxpayer Protection. But let me walk you through how undocumented do actually pay taxes, although it's called Taxpayer Protection. They buy a set of counterfeit documents, they fill the I-9, the employer accepts it at face value, and then they pay taxes. They pay these taxes here that are on the board. They purchase foods and services, property taxes. Who doesn't believe me? Well, Business Week says that. I don't say that. Business Week says that they pay taxes. So that's another myth that was created just to divide our community. Again, I'm not a lawyer, but I wrote down some things that Professor Kobach said. First, the comparison of the criminal issue with the civil problem. The efforts, he started saying the efforts to enforce the federal law. It would be like trying to enforce that bus for Rosa Parks. We need to modernize our state and our country. That's why Congress is there. That's why some laws just can't be enforced, and we have to change them and integrate them in our community. Friedman, he also talks about supply and demand. If we don't have enough workers, that's happening right now, what's going to happen with our produce? It's going to go up. And you know what Walmart is going to do? They're going to go to Mexico to buy those tomatoes. So we either import labor or we import produce. That's Friedman, right? Supply and demand. He mentioned Friedman. I talked about Chertoff. And of course you agree with it has nothing to do with 1804. We agree that terrorists, I'm from Argentina. I did the military service against terrorists in 1978. Of course I agree with that. But it has nothing to do with integrating these people to our community. So, is 1804 a just law when it, to me, is immoral, unethical, and unhuman? That's the question that I would portray. Thank you.
Thank you very much. I'm sure we've got a number of questions in the audience, and I believe we've got about 15 minutes for questions. Is that correct? Yes, ma'am. I'd ask that you stand up so that questions can be heard by everyone. Thank you.
First of all, I'm not a lawyer. I'm just a citizen of this community. I've been following you for some time. There's a gentleman that writes an editorial in the Tulsa World. I think he said it's Mike Jones. I wish he was here. I don't know, Mike Jones, are you here? Good. Email your back. I'd like to address my question to Mr. Kobach. I understand you've been in security for some time now, some involvement somehow in security. Is that right, sir? Okay. You said that we have somewhere in the neighborhood of 12 to 20 million illegal, I have the term is undocumented aliens in this country. Now, give or take a couple of million here or there. You said that one of the choices is amnesty. I do not understand, if we have this many illegal, undocumented peoples in this country on a security basis, we need to know who these people are, where these people are. Somehow we need to supply the means legally for the federal government of the United States of finding this out for our security. of this country. I don't know how it's going to come about, but we need to do it. To piecemeal it with an officer stopping somebody and saying, oh, you have the right documents, and then taking them to jail, and then going through all the legal process of deporting them, which is beginning to happen. I think it's ludicrous. It is not security. We're making people leave this country who are families, who are vital citizens of this country. Why are we doing this as people?
All right, I might answer that question and then answer a couple of other points that have been raised as well. I feel like it's a bit of an outnumbering here. I think there are a few points that might need to be answered. Regarding your question, ma'am, there are people, 12 to 20 million, and I think your argument, if I understand it correct, is one that I've heard before, and that is, well, we should legalize, we should have a path to grant some sort of legal status to bring people out of the shadows so that we can find out who the true national security threats are, hiding among the 12 to 20 million. The argument sounds good on first blush, but there's a problem with it, and that is it assumes that a terrorist or someone who actually poses a national security threat to the United States would actually come forward to get the amnesty, especially when, with only a few thousand ICE agents, what's the chances that he's already been operating below the radar screen? Why would he think that suddenly the radar screen is going to get that much more effective in catching him? And then if you looked even deeper at the amnesty that was proposed by the U.S. Senate in 2007, that argument was made quite a lot. Well, we need to get everybody registered, and then we'll know who the bad guys are. Well, even if a person did decide to come out of the shadows, whatever that means, and register, the way this amnesty was drawn up is that there was a 24-hour background check, because the numbers are so immense, 12 to 20 million people, unless you if you didn't have some sort of quick processing, then large numbers of people would not be getting their amnesty quickly. They'd be waiting years, and frankly, I think if that's the way it would be done, you'd have to have something like that to have a true background check. But there was no mechanism in place to ensure that the person offers a real name. I mean, there's already people who are arrested with multiple IDs. When you're fabricating documents, you can fabricate as many identities as you want and put your face on each one of those cards. So if a terrorist came forward, he could come forward and say his name was Rumpelstiltskin and say, that's my name. Here it is. I don't have any documents, but that's who I am. And then he would fabricate a clean identity. And not only that, the U.S. government would be handing him a card based on that clean identity. And so the idea that somehow terrorists are going to come forward and identify themselves is, I just think, ludicrous. Now, let me answer a few questions that were brought up, and there are just so many, but I'll just take two right now so I don't take all the time. I guess that's not really a danger. The myth that all of these immigration violations are somehow related to crime, and that actually, Sebastian said that all these actually are civil violations of immigration law. And I believe I quoted you correctly said, I'll be the first one to change my mind if they are breaking criminal laws, or something to that effect. Well, I've got news for you. Actually, the vast majority of aliens unlawfully present in the United States are breaking criminal laws. It is a civil violation to overstay a visa. That is not a crime. But the majority of people who are illegally present in the United States enter without inspection. That is a crime. The first time you do it, it's a misdemeanor under 8 U.S.C. 1325A. The second and subsequent times you enter without inspection, it's a felony. So it is a crime to enter without inspection. It's also a crime to re-enter after removal. That's 8 U.S.C. 1326. It's also a crime to misuse a Social Security number. I don't have the site for you, but I tried to get as many as I could. It's also a crime to falsely assert U.S. citizenship. It's also a crime to present false identification documents to a law enforcement officer. So merely in the process of being present unlawfully in the United States, the majority of aliens illegally present in the United States are committing crimes, both at the time that they entered and as a regular basis of just maintaining their life in the United States. And so there are crimes being committed, and I welcome your change of position. You're welcome your change of position on this issue because they are criminal violations. The other myth that I wanted to put back into place was it's not a myth, it's a reality, is the issue of taxes. Yes, it is true that unauthorized alien workers do pay taxes if they are working, if they are presenting a false Social Security number and are working under that number. Then they do pay those Social Security contributions. The federal government, however, released their figures on the amount of contributions that they believed were coming in under no-match letters. In other words, the name doesn't match the name and number don't match according to the Social Security's numbers. Those are placed in the earnings suspense file. The federal government's own numbers in 2004 say, yes, we're getting in about $16 billion in taxes every year through what are believed to be unauthorized alien workers. However, we're spending $26 billion every year on federal services and federal expenditures, also dealing with immigration law enforcement, for these unauthorized alien workers. So the federal government is running a debt of $10 billion a year. So yeah, we get some taxes, but they are far exceeded by the expenditures. A similar study was done at all levels of government, and it's much more complicated to study it at all levels of government because you have so many different forms of taxation. The most comprehensive study done so far is by a guy named Robert Rector. He's looked at every single form of tax that you pay if you're in the United States as an unauthorized alien or illegal alien, everything down to cigarette taxes, alcohol taxes, local sales, you name it. And he says if you calculate all those tax revenues coming in from the illegal alien presence in the United States, I use the term illegal alien because it's a term used in federal law, and it's shorter than alien unlawfully present in the United States. Anyway, you look at all those revenues coming in at all levels of government, they are still exceeded by $89 billion a year to services and other costs imposed by people here in violation of the law. So we're still $89 billion in the hole. Yeah, so we're getting taxes in. It's just that we're paying money out. And finally, the number up there of 0.06 from the Oklahoma Health Authority, those were individuals that they knew who were illegally present in the United States and were receiving services. Yeah, those are the only ones that they know. The problem is that Oklahoma, before this bill was passed, was not checking. The bill requires the state to check and requires other levels of government to check a person's unauthorized status. And so we really don't know what percentage of people were receiving these public benefits because we didn't have a mechanism in place to check. The federal government has a system that any state can use, and now Oklahoma is on that system. It's called the SAVE system, the Systematic Alien Verification for Entitlements Program, where you get into the same kind of computer databases used in the E-Verify, and the state official who's handing out the public benefit can find out right there if the individual is legal or not. So, we really don't know, and who knows how many illegal aliens were receiving public benefits before the law, but we know that after the law, none or virtually none are receiving those public benefits, and that's required by federal law. And believe me, if federal law changes and federal law suddenly says states have to provide these benefits to illegal aliens, I'll be the first one up here saying, okay, we have to follow federal law, because for me that's what it's all about, following the law. And, at this point, states are not allowed to provide public benefits to unauthorized aliens, to illegal aliens, with those exceptions that I mentioned earlier.
Other questions? Yes, sir. Could you stand up, please?
Prior to the passage of 1804, it's a relatively common event in law enforcement in Oklahoma for officers encountering undocumented illegal aliens or suspected illegal aliens, rather than pursuing the misdemeanor charge that's the basis of the stop, simply let those folks grow, creating kind of a form of de facto immunity. So is that something that you've observed in other states that don't have that type of legislation? And how do you think 1804, things like that, can impact that problem?
Yeah, it's been observed all over the country. In fact, it's observed even in my hometown of Kansas City. On the Missouri side, the Kansas City Police Department maintains the term you often hear in the press about this is a sanctuary policy. Some are informal sanctuary policies where just the rule is among the officers, that if someone's unlawfully present, we just let them go, and we certainly don't report them to the feds. Or you have formalized sanctuary policies like Los Angeles does with Special Order 40, and Denver used to, and Newark. A lot of bigger cities have those written into the ordinances. And Oklahoma's bill would prevent such sanctuary policies from continuing, and I think that's a good thing, because as long as it is well known that if you are unlawfully present in a given city, the local law enforcement is never going to report you if they happen to arrest you for some violation of law. They're never going to report you to ICE. Well, then that's kind of an invitation to people to say, come on in. Here, the local law enforcement is not going to cooperate with federal law enforcement. And, there is a mechanism for cooperation that's been in existence also since 1994. This is the Law Enforcement Support Center that Congress created. And basically, it's a 24/7 place where ICE officers are there around the clock in Williston, Vermont, and they accept calls from squad cars, police cars, all around the country saying, I've pulled over this individual, I've developed probable cause to think, I think this individual may be unlawfully present in the United States. Can you verify the person's status for me? And then they get an answer over the phone. An average of 1,388 calls are made by state and local police officers to ICE, to the Law Enforcement Support Center, every day. 1,388. So there are a lot of jurisdictions that are cooperating. And this kind of cooperation has been routine in American history. We have state jurisdictions, local jurisdictions, counties, and federal, and they all cooperate with one another in detaining individuals and then transferring them to the custody of the jurisdiction that would take whatever action is necessary. So if a state law enforcement officer apprehends someone who has just committed a federal crime or is wanted for a federal crime, he makes the arrest, he transfers the person. Same thing applies in immigration law. And so these are merely sovereign jurisdictions helping one another, and the legal basis for doing so is well established, and that's why Congress created the mechanism for doing so back in 1994.
I believe we have time for one more question. Yes, ma'am.
Sorry. I'm going to turn this way so you can hear me. I think one of my biggest questions is, you set up this false dichotomy of, deportation by the federal government or amnesty, and I think in some ways, even your concept of self-deportation, this is what I think so many of us are grappling with a deeper issue. In some ways, it's easier to say, okay, if these are our two choices, mass deportation. Because really, self-deportation is still getting at that same point of the question is, should they go home or can they stay? I think if we take it out of sort of the how come word of amnesty deportation, should they go home or can they stay? And when we say can they stay in a way that's regulated? And so I think what is more difficult for everyone, or at least more difficult for me, is the question of saying, because we have had a country and states that so far have said, we're not going to enforce speeding laws, or, to use your speeding analogy. And even in your speeding analogy, your idea of ratcheting up enforcement still embeds in it, I think, the question that we're all asking. Is there something about what we have done in the past, either benefiting from the use of people's work, of birds, and the fruit that I eat, or the fact that we let people come here and establish families? Is there something in that when we ratchet up enforcement of speeding laws, is it such that we say, if you sped in the past, now your choice is just, you need to slow down from now on. You need to do it right from this point in the future. Because in your speeding analogy, I've never sped, but if I have, I still have an option to not have something really bad happen to me. I just need to slow down on that stretch of road. And so I think the real question people are asking, and I wonder sort of maybe what you think of states' roles in this, is do we allow people to slow down, or do we say sort of you never get to drive anywhere in the West anymore, ever? So it's sort of like, is it a constructive concept of the rule of law, or is it, so for the people here, we say we have to handle this in some way. And it's interesting to me that one of your rejections of maybe of the amnesty bill was sort of how difficult it is to do, and that's the same with deportation. So are you open to maybe states saying, well, you're welcome. Are you open to states maybe engaging on the immigration question in a more sanctuary way than, as opposed to sort of way? That was your question. You're welcome.
I think I can handle it. Yeah. Okay, I'm going to break that down into two halves. The first point, I think, if I can characterize what you said, is that, using the speeding analogy, we're asking people to change their behavior, and maybe, I think you suggested maybe speeding might not be analogous because there are real benefits, so you claim, from the people breaking our immigration laws. For example, that we might get products more cheaply at the grocery store, and that's a whole other debate. But I would say the same is true of speeding. A person could argue that there are benefits from speeding as long as the individual is not drunk and as long as they're driving safely. They are engaging in they get to work faster. They engage in more productive time at work. They spend less time on the road. They could make the argument. There are also costs to speeding. There's a higher risk of accident and death if an accident occurs. But the same is true with our immigration laws. People will say that there are benefits to enforcing these laws because you're protecting U.S. workers who are in direct competition. And by the way, in every single field where illegal labor is present, the majority of workers are still U.S. citizens. So U.S. citizens are in direct competition here. Yeah, there are benefits to enforcing the law for those U.S. citizens because you're stopping the wage depression that's occurring when illegal labor comes in. And there are also costs because the person at the grocery store might want to get that head of lettuce a couple cents cheaper. By the way, it's estimated that even if all of our wages in agricultural produce across the country increased 50%, which would be an extraordinary increase, but suppose all of the illegal labor in that field disappeared, something like that probably would have to occur to get lawful workers and U.S. citizens back into those jobs. It would only increase the average U.S. household's cost of groceries by $10 a year. Only $10 a year. Why? Because actually the labor component of what you pay for at the grocery store, tiny, a really tiny percentage of it. So that's, I guess, my answer to that is that there are costs and benefits for laws that we have in terms of whether we want people to violate these standards of behavior and whether we don't want to. Now let's go to your next question, which was, well, am I open to states acting in a way that's more permissive or more inclusive, states adopting policies that are more tolerant of illegal immigration or more attempt to maximize, I don't know. The shorter answer is I'm open to the states doing anything that is consistent with federal law. And as a lawyer, I mean, that's my position in these cases. There are some things states can do, and there are a lot of things states can't do, by the way. Oklahoma's bill is a collection of things that states can do, but there are things that states have tried that they cannot do, and I'll be the first to admit it. Those would be preempted under federal law. So if Congress changes the law and says we think states should have the option of providing these types of public benefits, in-state tuition, formally recognizing them as residents and giving them driver's licenses, you name it. If Congress changed that law, then I'd say, yeah, states are free to do that. But I guess the larger question wrapped up in that is, do we have a role for states in this system at all? And I think not only do we have a role in terms of the legality of these state statutes, that they certainly are permissible, but at this point we probably need the states in the system because of the dearth of law enforcement resources at the federal level. It's just so difficult for such a small cadre of ICE officers to try to enforce the law nationwide that states actually can help if they want to. In most cases, there are two driving forces pushing states to act. And some people will say, oh, it's all racism. I don't accept that, and I think if we just say, well, your arguments are racist arguments, so go home, then we may as well not even have this as Symposium. There are two forces driving states to act. One is the cost of providing services, and I've talked about that, and the other one is protecting American workers, because American workers are seeing their wages go down. George Borjas, Harvard law professor, is the preeminent economist who studied this across the country, and he says that he's calculated that for every 10% increase in the labor force due to illegal immigration, or the same principle would hold to legal immigration, you would see wages drop 7 to 8% in the short run and 4% in the long run. So we have to make a decision. Do we care if the U.S. citizens working alongside the unauthorized aliens are getting paid less? I do care. In Oklahoma here and where I live up in Kansas, we do have a lot of meatpacking. Many of you may know that meatpacking used to pay about $12 to $15 an hour. About 15 years ago, it was a pretty decent wage. Now your average wage in meatpacking in this part of the country is somewhere between $8 and $9 an hour. Why have wages gone down in this one industry when wages are going up everywhere else, or at least staying constant everywhere else? And the answer is, of course, the influx of illegal labor. And so, there are a lot of people in this equation, and we have to consider the concerns of U.S. workers, too. Thanks.
I'd like to thank our panel for